All right, welcome to another meeting of your Committee Number 7, Corporations, Elections, and Political Subdivisions. We have an aggressive agenda today. We have to finish up by 2:20 p.m., but we have 4 bills that we would like to try to hear. So committee, enjoy your lunch. Hopefully that means you ask less questions while you're eating. I'm just kidding. Ask all the questions you need, but seriously, don't ask questions. Okay, will you please call the roll, Barb?
Representative Chadwick?
Here.
Representative Haroldson?
Time, he's coming.
Representative Harshman? Vice Chairman Knapp?
Here.
Representative Newsom?
Excused.
Yes. Representative Ottman? Yes. Representative Wiley?
Here.
Representative Yin?
Here.
Chairman Olson?
Here.
Here.
Thank you.
You're welcome.
Oh, a bad eraser. Oh, no, I've got it.
Okay. So we're going to consider the bills in the order that they're noticed: 85, then 129, then 164, and then 173. House Bill 85, for-profit public benefit corporations, is a bill from the committee that I also chair. So I'll be presenting that bill, and I'll turn over the chairing during that bill to Representative Knapp.
Okay, committee, before us, we have House Bill 85. Would you like to present the bill, Mr. Chairman?
Yes, thank you, Mr. Chairman. So this bill is, this bill has been worked over the interim by your Select Committee on Blockchain, Financial Technology, and Digital Innovations. Worked actually through 2 interims this bill has. So they've really spent a lot of time, that committee held a lot of testimony and really worked through this bill over 2 interims. In summary, what this bill does is it creates a new classification of a corporation. That corporation is a for-profit public benefit corporation. What that is, in summary, is a corporation that balances stakeholders' pecuniary interests with advancing some public benefit goal. So, in other words, the way I like to look at it is think about a traditional corporation. Traditional corporation, you would form it for the purpose of a pecuniary interest. That's why you form a corporation. You want to make money. You sell stock in your corporation to people who want to make money in your corporation. And so they join your corporation through the stock as a shareholder with the purpose of advancing a pecuniary interest. If the corporation, the officers and directors of the corporation, were negligently failed to advance the pecuniary interest, this isn't a traditional corporation, then I might, as a shareholder or a stockholder, I might have a pretty good lawsuit against them for failure of their duty to me, which is to advance my pecuniary interest in the company. That's a traditional corporation. This for-profit public benefit corporation still has the interests of the pecuniary interest at heart, but it adds another flavor, and that's advancing a public benefit goal. So this allows you to basically take your mission statement, whatever it may be, that's the mission statement of your company. It's for pick your scenario XYZ, and write it straight into your formation documents, so that if the officers and directors are not necessarily advancing solely pecuniary interest, but they're advancing a public benefit, then they can't be sued for the failure to advance a pecuniary interest. Here's an example that would work in Wyoming. The example would be pick a wheat farmer, for example. And let's say it's an organic wheat farmer. And let's say that in the mission of this organic wheat farmer, they have it written straight into their formation documents. We are organic wheat farmers. Our mission is to provide healthy, productive food for our communities. But it may not necessarily be the most economical business model. It might not. Just selling regular wheat might be far more economical. That would be an example of how you would utilize this corporate formation that I think would work in Wyoming. Some states allow for these public benefit corporations. Delaware is one of them. In this bill, we follow that model pretty closely. You can either form this corporation from the onset, or you can take a traditional corporation and convert to a for-profit public benefit corporation, excuse me. So with that, Mr. Chairman, I'll just walk you through the bill. Page 2 of the bill, we have in the middle of the bill a definition of the for-profit public benefit corporation. It is a corporation operated, number 1, for profit, so that's the pecuniary interest, and then number 2, you'll see on line 15, intended to produce a public benefit. The definition does not apply to modified public benefit corporations, so we're not modifying nonprofit corporations, even though one of the ways to at least theoretically think about this company is that it is some type of a blend between a nonprofit and a profit. Nothing is modified in the nonprofit statutes. Going over to page 3, 1732-103, the Wyoming Business Corporation Act applies to for-profit benefit companies. So what that means is that the existing corporate laws are going to apply to the for-profit public benefit corporation, and to the extent it's not inconsistent, this chapter then controls. So the way to think about that is they're just gap fillers. All of the existing law that we have built around our for-profit corporations still applies. We're not changing that unless it's modified herein in this bill. Next paragraph talks about how a public benefit can elect to become or convert to a for-profit benefit corporation. Down at the bottom of the page, we talk about what has to be in the contents of the articles of incorporation. So these are the formation documents. They have to contain, in addition to all the requirements that already exist in law, they have to contain, over on page 4, identifying one or more public benefit. That's fairly obvious, right? That's the purpose of this organization, is you have to set forth in your formation document what is your public benefit. So number 1. Number 2, they have to state that they are a for-profit public benefit corporation. That needs to be stated and very clear. Rest of the page, lines 8 through 23, are the naming conventions. So if you form a limited liability company, you have to put the word LLC at the end of it. Similarly, if you form a public benefit corporation, you have to put the letters PBC or P.B.C, or spell it out, public benefit corporation. So it has to be in the name of the company so that anybody who's dealing with this company or anyone who's investing in this company should know from the onset, based on the naming convention, oh, this is a public benefit corporation. I see. A B Corp. Page 5, stock certificates 17-32-106 have to note, so similarly to the naming convention, the stock certificates have to note conspicuously that the corporation is a for-profit public benefit corporation. Bottom of the page, any notice that's given for a for-profit public benefit corporation shall state conspicuously that the corporation is a for-profit public benefit corporation. Duties of the directors. So this is what I talked about in middle of the page of 6. This is what I talked about in my opening remarks, Mr. Chairman. Simply that the board of directors for the B Corp shall manage and direct the business affairs of the for-profit B Corp in a manner that balances the pecuniary interests of the stockholders and the public benefits identified in its articles. So its mission statement. This is the meat of what this bill does. This is the meat of what sets it apart from a traditional corporation. Bottom of page 7, 17-32-108, periodic statements and third-party certifications. These are notices that have to include a disclosure that they are for-profit public benefit interest corporations. So there's a list of requirements, notice requirements on page 8, going over to page 9, finishing those notice requirements. Actually, that's the end of the bill, Mr. Chairman. Some examples real quick, committee, I'll give you some examples because this type of formation does exist in Delaware. Examples that you may know of, one would be Kickstarter, another might be Ben & Jerry's as an example. And then the wheat example that I gave you, which I think really comes home for Wyoming. Last thing I'll say about the bill, Mr. Chairman, is there is a fiscal impact statement. It's pretty minimal. There is a $17,880 fiscal impact for modifications to the internal and online filing system with the Secretary of State's office, and a $45,120 fiscal note for modifications to create the new entity type itself in the filing system. With that, Mr. Chairman, I'll take any questions.
Questions from the committee? Representative.
Thank you, Mr. Chair. Mr. Chairman, I just had a couple quick questions. One, I was wondering, with the development of this and where it went or who it was sponsored by, it was sponsored by blockchain instead of the corporations committee. So I was kind of wondering about that. And then also, as you went through there on page 6, we had established that these corporations need to be designated as PBCs. And I had read also about Bs, and you said Bs. So what's that? Thank you.
Chairman Olson.
Sure. So the first question, Mr. Chairman, Representative Ottman, the first question deals with how this bill gets in front of you. So the Select Committee on Blockchain, Financial Technology, and Digital Innovation is a statutory committee, so it can sponsor its own legislation. Why it was, I can't recall, it was 2 years ago when it was assigned as an interim topic to the committee. So other than we had, the only thing I can recall is that we had industry that was interested in it from the blockchain sphere, which is what made it land inside of the Select Committee. So it very well does fit within the subject matter of corporations, which is why it's here now in front of you. But it was just that that's the industry that brought it to the attention of the legislature. So that's the first question. The second question, yes, the Delaware refers to them as B Corps. That's what they call them in the short form. So a for-profit traditional corporation might be referred to as a C Corp or an S Corp, depending on what its tax status is elected as. So it's just a short terminology for this in the world. We just refer to them sometimes as B Corps, benefit corps. You can, it's just shorthand is all it is. Probably more accurate in the way that we've written our statute to just call them, I just stumble over the words for-profit public benefit corporation because it's a mouthful. So I just called it a B Corp for short.
Mr. Chairman, I could provide some context on the first question, if I may.
Representative Yin.
Thank you, Mr. Chairman. So in the Select Blockchain Committee, we did actually have testimony from a company that enjoyed our blockchain laws, and they wanted to also domicile in Wyoming their corporation, but they were interested in having this benefit corporation status to be able to put some of their focus on furthering technology, even if it might not be directly profitable to shareholders. So that's the reason there was a company that was interested in us having it, so they could register in Wyoming as well, because they enjoyed the other laws that we have around blockchain. They wanted this to enjoy that benefit status as well.
Representative Ottman.
Thank you, Mr. Chairman. Just a follow-up question. I was wondering, over on page 6 again, because this was very interesting to me. Corporations is new. When we're talking about the pecuniary interests and the public benefits identified in the articles of incorporation, how is that watched? How is that, industry reports or stuff to the Secretary of State in the state where it's established, or? Thank you.
Thank you, Mr. Chairman, Representative Ottman. So we're talking about a document that's called the Article of Incorporation. That's your formation document. It is filed with the Secretary of State's office, and it becomes, if you file online or you file a paper version, whichever way you file, it becomes a PDF document literally on the Secretary of State's website that any member of the public could access and see. So if you knew that this for-profit benefit corporation existed, but you wanted to know, hey, what is its mission statement, if you will, what is its public benefit, you could search it, find it on the website, click directly on the formation document and read in the black and white. That might be a follow-up question for the Secretary of State's office in terms of how the Secretary might choose to enforce the formation of the company. From my understanding, at least in my practice of law, when I do form companies, if I'm forming it online, the Secretary of State's system is basically watching to make sure I have something in every article that's required as I'm putting it in, but it's not checking the substance of that information. So I could put whatever I wanted in it. I could say, for example, I suppose I could say no mission statement, no public benefit, and I could probably even file it, and the Secretary of State's office is going to my guess is just approve it because the box is filled. You'll have to ask them if they would check that. Otherwise, I mean, that would be enforcing, that enforcement would probably rest on any potential stockholders or shareholders who would say, hey, I thought this was a public benefit corporation. You told me this is what it is. It doesn't say it in your articles. What's going on? What's the funny business?
Any other questions? I had one. So that balance that you strike between profit and benefit, is that written anywhere in the articles, that percentage, or is that a detail that they put on there?
Mr. Chairman, that's a really good question, and I think it would come down to a stylistic or legal preference in terms of drafting that document. In terms of what the law requires, the law just says, and that's on that page 6, 1732-107, subsection A. It just says that they shall balance the pecuniary interest with the public benefit. So in my mind, that means balance means it's got to be equitable. It's got to be fair and even. It's got to be a 50-50, at least in my mind, if I'm assigning a percentage to it. But I suppose from a legal standpoint, I could argue that equitability, balancing it, doesn't necessarily mean that. It could be, maybe I could get away with a 60-40, and I might put that in the mission statement. As an attorney, I would probably not recommend someone to do that. I would just recommend that the article be, normally you might recommend that the article be really general. Most articles of incorporation in America have a very similar statement, and they just say, for any lawful purpose. This corporation is formed for any lawful purpose. That's the standard that you put in so that you don't lock yourself into a box. This really, by putting your mission statement in, I feel like you are locking yourself into a box. So you've got to be very careful in what the verbiage is, but I probably wouldn't recommend assigning an exact percentage as a lawyer anyway.
And I had just one more question. So I would guess one of the concerns is for benefit can mean a lot of different things. Is there a concern that these companies may become, let's say, political tools versus actual companies?
Mr. Chairman, at least that's not a concern of mine. I would say that rests with the freedom to, the freedom to associate in our Constitution allows you to associate and form an organization and a company for whatever, you should be able to form it for whatever purpose you want it to be. And if the stockholders, if that's really clear that it's a political purpose, that organization is really trying to further that public benefit and it might be hyper political, as long as that's really clear in the mission statement so that those who are investing in the company know exactly what they're investing in, then I feel comfortable with it.
Thank you. Representative Ottman.
Mr. Chairman, thank you. And Mr. Chairman, just a follow-up. Could you repeat the fiscal note amounts? And also, I was wondering, is that for us contingent upon this bill being passed? Or is that a biannually, semi-annually? Or when the companies file these, what will their charges be, or do we know? Thank you.
Chairman Olson.
Thank you, Mr. Chairman. Representative Ottman. So there is no appropriation in the bill. So what I was speaking to is specifically a fiscal note that came from the Secretary of State's office. So right now they would absorb this cost if you pass this bill. If you don't pass the bill, there's no administrative cost to the Secretary of State's office. And the figures are, there's two figures. One is $17,880. And that is to modify their internal and online filing system. And they've got a list. Basically, when you go in online and file, there's a drop-down box that you click when you're forming a company. And you're going to have, that drop-down box is going to have the B Corp option. So you're choosing it. So I believe that $17,000 is pretty much to create the new subtype public benefit. That's in their software expenses. And then the second one is a $40,120, and that is to create the new entity type in their, broader in their software system. So I believe the Secretary of State's office could probably speak more in detail to those expenses. And now I don't recall your second question.
Representative Ottman.
What the charges would be for the
Oh.
entities that choose to do this?
Right.
Mr. Chairman.
Mr. Chairman, Representative Ottman, I don't recall seeing in the bill that we changed the dollar figure, so I believe it's the same fee that it currently is to form a corporation, which is $100, or if you form it online, $102, because you got to pay the service fee to do it online. And then you'd have annual renewal fees, which I think are $60.
Any other questions? If not, we will open it up to the public. Do we have anybody from agencies? Please state your name.
Good morning, Mr. Chairman. My name is Jesse Naaman. I'm the Deputy Secretary of State. Secretary Gray sends his regrets as he is in the State Building Commission meeting. He has asked me to speak on his behalf this morning. Secretary Gray asks this committee to vote no on House Bill 85. House Bill 85 encourages a new type of corporate entity structure in the state of Wyoming, the quote, for public profit benefit corporation. While a for-profit corporate structure, sorry, I lost my train of thought here. While a for-profit structure encouraging a public benefit sounds great, the bill's definition of a public benefit leaves the reader of the bill entirely unclear on what exactly constitutes a public benefit. So what is a public benefit? If you ask 10 people, you will get 10 different answers. The answer that concerns Secretary Gray is that in the prevailing court of a public opinion is that the type of benefit would be encouraging, the latest fad in a long line of radical ideologies. These include radical environmentalism, Marxism, or any type of woke agenda item which would be pushed in the mainstream media right now, none of which is part of Wyoming's values. Mr. Chairman, Wyoming is one of the most corporate-friendly states because we encourage the traditional principles of shareholder wealth maximalism, something that naturally promotes Wyoming's mineral, agricultural, and tourism industries as they naturally complement each other. Expanding it to something entirely different, something we have no idea what will be encouraging, and something that the Secretary fears is another way of introducing and incentivizing a concept called stakeholder capitalism. Secretary of State Chuck Gray does not believe that this is appropriate for Wyoming. He does not believe that enacting and implementing legislation which condones and encourages corporations which may be intent on harming Wyoming's values and way of life. Secretary Gray would also point out this bill was killed in the House 2 years ago. Secretary Gray would urge a no vote on this bill. Thank you.
Mr. Chairman.
Representative Yin.
Thank you, Mr. Chairman. Deputy Naaman, sorry, please, is it
Mr. Chairman, Representative Yin, it is Naaman, and that's okay.
Naaman, my apologies. I'm gonna write that down, make sure I don't do it again. Is there anything preventing the Secretary of State's office from implementing the bill if it is passed?
Mr. Chairman and Representative Yin, not to my knowledge, as we know, there would be a fiscal impact, but we do have filings for various types of corporations.
Great, thank you, Mr. Chairman.
Other questions?
I have a question.
Representative Ottman.
Thank you, Mr. Chairman. Deputy, what's the difference, or is there a difference, or is it new, or are they able to be exchanged between a B and a PBC corporation?
Deputy Secretary.
Mr. Chairman and Representative Ottman, I don't have an answer for you on hand today. I regret. I apologize.
Other questions?
Thank you.
Thank you. Comment from the public? Please state your name and the agency you represent?
Yeah, good afternoon, Mr. Chairman. I'm a member of the public. I'm actually not here on behalf of an agency.
Okay.
My name is Matt Kaufman. I'm an attorney with Hathaway and Coons here in Cheyenne. I'm also a Governor Meade and Governor Gordon appointee to the Select Committee on Blockchain. I serve with Representative Olson and Representative Yin. I'm here today to speak on and behalf of this bill. I was involved in the drafting of this bill 2 years ago and presented it. I'd like to specifically comment and clarify a few points that have been brought up today. First and foremost, it's really important that everyone understand this. If you go on Google and you search benefit corporation, chances are you're going to see a website that's for the designation or certification of B Corps. That is absolutely and fundamentally different than what we are talking about here. There is an organization out there that certifies B Corps as something having a greater social good or a benefit. Any company can go get that. That is not a legal designation. What we are talking about is a public benefit corporation as a legal entity form. In other words, it's a different flavor of corporation, as Chairman Olson explained to you all. So I just want to make sure that that's really clear because a lot of people get confused about that designation. B Corp is something that companies might espouse as, hey, I've got this certification. I went through the B Corp certification process. That is completely irrelevant and different than what we're talking about. Yes, it is true that some people refer to public benefit corporations as B Corp. B Corps, in my estimation, that's
Including me,
a,
apparently.
it's a little bit of a misnomer. These public benefit corporations are still corporations for all practical purposes. They are oftentimes C corporations. They're still taxed as C corporations, although they can elect to be taxed as an S corporation as well. But I just wanted to make that distinction very, very clear. With respect to the reason that I was so passionate about bringing this business entity type forward is, first, it's a competitive issue. About 37 states have adopted some form of the public benefit corporation. Wyoming is one of the few that does not have it. I have personally counseled companies here in Wyoming that have left Wyoming because they want to be designated as a public benefit corporation. What's an example of some of those types of companies? I met a fantastic young woman from the University of Wyoming that developed a fabulous software for helping companies train and anticipate or track sexual abuse and sexual trafficking. And she had a hard time raising money as a nonprofit. She just couldn't get any traction. Her investor base was asking her to be a public benefit corporation because they knew, right, that this wasn't about maximizing shareholder value as much as it was about helping others and getting the software out there. But yet, for various reasons, the idea of making it a nonprofit was not attractive to those investors. So that is a common problem, actually, in this day and age. It's coming up more and more and more as companies orient themselves. What I would like to point out to the committee, and believe me, I spend my days buried in the Business Corporation Act, so I can recite this chapter and verse to you. The primary difference between a public benefit corporation and a traditional corporation is we are just modifying the duties of the directors. You've probably all heard of the Revlon makeup company. There is a famous corporate Supreme Court case out there called the Revlon case, which has provided a progeny of cases called the Revlon doctrine. The reason that case exists is because Revlon went through a merger where they opted not to maximize shareholder value in lieu of, right, finding and picking some companies that they thought they fit better culturally with. A whole bunch of shareholders sued them and said, hey, you have to take into account the shareholder interests, and your duties as directors is first and foremost to maximize shareholder value. And the court said, they're right. That created the outgrowth of the public benefit corporation because entities would like to have the flexibility to say, I want to do something good as well as be for profit. This is not designed to be a nonprofit entity. So we want to relax those director duties just slightly so that the directors don't have liability in taking on that mission. Representative Olson gave a very funny and ironic example. The one I often give, one of the most famous public benefit corporations is based out of Boston, and they are a bread company. They're publicly traded, and their mission is we only want to support American-grown wheat and crops, right? We don't care if that hurts our bottom line. That is the point. There are energy companies, right, that are exploring this and saying we want to support American oil and gas and things like that. To the point that was brought up earlier by the Secretary of State's office, could these entities be used for other social purposes? Yes, they could, but they can also be used for good purposes that are consistent with Wyoming culture and Wyoming efforts. So I just wanted to make that really clear. The last thing that I'll say is, again, I was part of the effort 2 years ago when we tried to get this bill passed. I was a little disappointed personally that the conversation took that turn that was solely focused on the ways these entities could be used for, political purposes. Again, what I would say is they are not nonprofit entities. If you're a nonprofit entity, there are specific restrictions and requirements under the tax code about what you can and can't do if you want to maintain that tax exempt status. For-profit corporations or traditional corporations don't have that restriction, but they're bound by director duties and obligations, which limit how far they can go and what they can do without shareholder liability. All the public benefit corporation does is say, we will allow you, if you so choose, to modify those director duties so we can take into account other thoughts, ideas, and stakeholder interests in fulfilling your duties. And then we set the standard from there. So I'll stand for any questions, but I just wanted to take a few moments and provide those clarifications.
Committee, any questions for Mr. Kaufman? Representative Haroldson.
Thank you, Mr. Chair. Mr. Kaufman. So a couple questions. One, what would happen if there were to be a for-profit entity that went into this B Corp? Is there a way that they can transfer into that, or does it have to be established as that? That'd be the first question.
Yeah, Mr. Chairman, through you. So I think, again, I'm touchy about the B Corp designation only because that's
Yep,
something
nope, I get
completely,
it.
but if a for-profit corporation under this act wanted to transition into a public benefit corporation, I don't think that this act in any way prohibits that, but there would be a notification required, right? Because we do, a lot of the statute is oriented at what Chairman Olson said, and that is putting people on notice of what they're getting into. So in other words, if you are going to invest or hold shares in a public benefit corporation, every state that has passed this act has some form of disclosure requirement like we have in this one to say, understand that the director duties might be different, right? That might affect your remedies as a shareholder. And in addition to that, we're going to have to notice things like on stock certificates and in the articles. So my suspicion is it's going to be a process, right? Depending on how many shareholders the corporation has, there might be a notice process, a meeting process, a shareholder approval process. They're going to be bound by their own corporate governance requirements of that entity, but I don't see any reason that they couldn't do it if they can meet the requirements of the statute. I might add one thing to that. That is why there is a prohibition, though, on non-stock for nonprofit entities in converting to this, because we don't want to create a mechanism whereby someone can try to back into a for-profit business by starting a nonprofit. Those are fundamentally two different things. So there is a direct prohibition in the statute against that.
Representative follow-up.
Yes, thank you very much, Mr. Chairman. So the second question is there any recourse that a shareholder could have in this situation? If because obviously I hate that we live in worst case scenarios when we do these things, but we have to live in worst case scenario. And so let's say that there is a shareholder that we have one of these entities that completely goes off the rails and takes it into the ditch. Is there any recourse? Because obviously a for-profit, there is the suit, the civil side. What about in this case?
Yeah, Mr. Chairman.
Mr. Kaufman.
Again, through you. Yeah, great question. So I would refer you to section 1732-109 in the bill. In case you're not familiar with the concept of a shareholder derivative action, which exists in corporate law, the idea of a shareholder derivative or even a shareholder direct action is that shareholders believe that the directors or the officers of the company are not upholding their duties or not acting in the best interest of the company. So you derive a claim from their actions or non-actions, right, that you can bring on behalf of the company to either enforce rights, remedies, or hold them to some standard of duty. That right still exists for public benefit corporations, so you still have the right to bring a direct or derivative action. However, this section slightly modifies it in that it creates a threshold, so you have to have a certain ownership percentage level before you can bring it. The idea being, you don't want someone that has a 0.00001% interest, right, and they take some beef with this balancing action of balancing the interests, and they still have a right of remedy. So yes, the remedy exists, just like in the Corporation Act. It's just a slightly heightened standard.
Representative Yin.
Thank you, Mr. Chairman. Mr. Kaufman, with an LLC, is there anything stopping someone who runs an LLC to do all of the political actions that people would be worried about with the for-profit benefit corporation?
Yeah, so Mr. Chairman, again, through you, yeah, don't tell Representative Wanitzer I said this, but in the LLC Act, we have something called the low profit limited liability company, which quite frankly, no practitioner ever uses because it's a tax disaster. It basically doesn't work with the tax code. And so there is conceivably a pathway under our LLC Act for limited liability companies that want to consider themselves low profit and arguably change that standard of conduct. In practice, that hasn't really been carried out. It hasn't been tested by the courts. And as I said, nobody really uses that because of the way that LLCs are traditionally taxed. That being said, both the existing Corporate Act and the LLC Act discuss director duties, or in the context of an LLC, manager duties, and it lays out standards of conduct. Again, this is no different, right? This act already adopts the Corporation Act standards of duties. The LLC Act and the Corporation Act already have some references in there, right, to directors or managers being able to consider outside interests, right, or the community or things like that. So that's not a new concept. What's the new concept is just now we're actually changing that director standard. Did I answer your question?
Any other questions? I had one. So say worst case scenario, a company could actually form, and I would say have complicit shareholders, operate at a loss, and put 100% towards the benefit versus the profit. Because there's no set limit on what profit should or could be. If the shareholders are okay with the bylaws to the corporation, that could possibly take place. I worry about a blur between nonprofit restrictions and moving to a nonprofit with no restrictions. How would you comment on that?
Yeah, so Mr. Chairman, if I understand the question, I mean, at no place in our Corporation Act, LLC Act, or the Nonprofit Act do we really put requirements on entities as to how they have to operate financially, right? I mean, people take a risk when they start a company or run a company that they run it successfully, profitably. So this entity is no different in that respect. If the directors were negligent or just did a terrible job of managing the risk and managing the company such that they overemphasize some public purpose over their shareholders, that doesn't get them around any shareholder liability. It doesn't get them around any contract liability. It doesn't get them around any other forms of civil liability with companies or individuals they might do business with. Again, all we're talking about modifying is the standard at which we hold those directors, to where in a traditional corporation, you say maximizing shareholder value is the gold standard that you are obligated to. In this context, you can balance that with some other things. Thank you.
Any other questions?
I was just going to add, Mr. Chairman, I think to that example, I would point to the statute itself, the fact that it requires that you balance a pecuniary interest and your public benefit. I don't think you could intentionally run the company into the red and just pursue your public benefit. I think that if those were the facts presented to a court would say, well, you're not balancing these two things if they either negligently or intentionally ran it into the ground. So I would say that's the statute provides some consumer protection in that respect, but ultimately I still believe that as long as you're entering into the company and you know what its purpose is, then you shouldn't get involved with the company if you don't believe in its mission statement.
Representative Ottman.
Thank you, Mr. Chairman. And just to say, it does say a for-profit will produce a public benefit and operate in a responsible and sustainable manner. So it does have that. I was just wondering, is there any specifications? Is this for just brick and mortar companies in Wyoming, or could this be corporations on paper, that maybe have a mailing address here or something like LLCs or something? Thank you.
Mr. Kaufman.
Yeah, Mr. Chairman, Representative, there's no specification like any other entity that we have under Wyoming statute. there's really no specific requirement in the statutes. And we do have entities like banks and other things that are required to have physical presences, but in terms of the Business Corporation Act or the LLC Act, there's no requirement that it be a physical brick and mortar business.
All right, thank you.
Thank you.
Are there any other public comments in the room? Okay. Any public comments online? All right, I will close public comment. And what is the pleasure of the committee?
Move the bill.
Second.
It's been moved and seconded. Representative Yin. Okay, let's go through the bill. Page 1. Page 2, any changes? Page 3. Page 4. Page 5. Page 6. Page 7. Long bill. Page 8. Page 9. Page 10. Page 11 for the effective date. Any discussion? Representative Yin.
Mr. Chairman, so I am in the select committee, but I think I do want to talk about why it came out of the select committee. And I think the question for the select committee and before us is essentially, do we want companies, for example, one that said, we want our mission to be, I want to make sure that I use only Wyoming energy or only domestic grain to make my flour. Do we want those companies to choose to domicile in another state, or do we want them to take advantage of Wyoming business law and possibly provide Wyoming jobs? So I think we are one of 35. We are one of those states that doesn't have it, but 35 other states do. 37. My apologies to Mr. Kaufman. It just seems easy for me to say that, yes, why wouldn't we want these businesses in Wyoming? I get that there is a concern that we also heard from Secretary Gray that there are businesses who do things that don't agree with Wyoming values. They're probably not going to domicile in Wyoming. They're going to domicile in Vermont, right? So I think that for those folks who want to do things that we don't necessarily agree with, they'll probably do it under an LLC or they'll do it in another state. I think there are plenty of public benefits that do fit with Wyoming values that have companies coming to us, as we heard from Mr. Kaufman say, who does business organizations, say they want to do this in Wyoming and it fits with Wyoming and it'll help the people of Wyoming. So I think it makes sense. So those are my comments.
Any other comments? Okay, we'll call for the question. Roll call vote, please.
Representative Chadwick.
Aye.
Representative Haroldson.
No.
Representative Harshman.
Aye.
Chairman Knapp.
No.
Representative Newsom, all Marcus excused. Representative Ottman. Representative Wiley.
Aye.
Representative Yin.
Aye.
Chairman Olson.
Aye.
5 aye, 3 no, 1 excused.
Representative Yin, you have extreme interest in managing this one on the floor. You gave such an eloquent speech convincing us to vote for it. I thought you should carry that to the floor.
Okay, we have 5 ayes, 3 noes. House Bill 85 has passed the committee.
Okay, the next bill for our consideration is House Bill 129, Wyoming Private Employees Retirement Savings Plans. We have the bill sponsor, Speaker Pro Tem Stith.
Thank you, Mr. Chairman. Present to you House Bill 129, ask for your favorable consideration. This bill is essentially a study bill. It asks for $50,000 to do what amounts to a feasibility study for having an automatic enrollment in retirement for employees of private employers with the option to opt out if someone does not want to participate. So why this bill? Why now? And why is it a study bill instead of actually doing it? So first off, as you all know, our Department of Health on the state pays for most of the cost of nursing home beds. Most of the people who end up going to the nursing home can't afford to be in a nursing home. And as a result, the state ends up paying for it. That problem it exists now. That's likely to get worse in the future. So the long-term trend is that as those nursing home costs, for example, go up, more and more of the burden will be upon the state to pick up the tab. Right now, we have more than half of our citizens who are between the ages of 65 and 74 have no retirement at all. They got nothing. And so why is that? It's because either their employers aren't offering a 401k plan, or our current system, of course, is an opt-in plan. And so what this bill would do, it would be to set up a task force to study and make recommendations back and have a report done by September of 2024 to say, does this make sense for Wyoming? Should we do it? And this is not a new idea. This has been around for a long time. Before I was in the legislature, this was studied extensively. No action was taken at that time. But you might want to say, well, why are we doing it again now? We've already studied this once. Why are we studying it again? What's the point of studying it? Two reasons. One is that federal law has changed. On December 29th of 2022, the Setting Every Community Up for Retirement Enhancement Secure Act 2 was signed into law. That may end up doing something similar, but it's going to be a federal program with federal strings attached. And the question is, do we want the federal government to be telling us how to do this, or do we want to craft our own plan? Because the federal law is brand new, and so we don't have rules or regulations from the federal government on that yet. So in considering this, I was considering having this drafted to be just a bill that would change the law and just say every private employee, you're automatically enrolled in a 401k unless you opt out. But because we've got this federal law overlay now, I think it makes sense to study it, take a deep breath and say, does it make sense for Wyoming to do its own customized retirement plan? And essentially, the gist of this, or the thought behind this, is the power of defaults. If the default case is that you're enrolled in retirement, you're much more likely to be enrolled in retirement than if you have to affirmatively seek out an employer who offers one, and you have to choose to enroll. So walking through with that as the sort of big picture background, just walking through the bill briefly, the bill is the bill's not doing all that much, but it is a bit lengthy. Section 1 establishes a task force with certain members. Those are on page 2. There is what I think is a clerical mistake that I have here at the bottom of page 2 and the top of page 3. We have one member of the Senate appointed by the President of the Senate, and it says to be a non-voting advisory member. So that's, I think that's a mistake. And because task forces don't really vote anyway, they don't have voting power, I think it would be cleaner to, on page 2, line 20, to just, after President of the Senate, to just delete the balance of that. And the balance of the next line as well. The same thing happens on the top of page 3, where you have one member of the House appointed by the Speaker of the House. And I think, again, on page 3, line 3, it would make sense to just, after the word House of Representatives, to just delete the rest of that, because I think it doesn't make sense to call them non-voting if this task force doesn't really vote anyway. It's going to make a recommendation, presumably. The page 3 continues on with some of the administrative aspects of it. Page 4, starting at line 4, subparagraph F, essentially
So, sorry, Mr. Speaker Pro Tem, can we back up to that non-voting provision that you're potentially wanting to amend. On page 9, top of the page, the report, there's a report that gets produced to appropriations, that's bottom of page 8. But the report may include proposed legislation. So at least in my experience with task forces, which is limited, but in my experience, you have voting and non-voting members on the task force because they may advance legislation to their sponsor committee. It appears that the way the bill is designed, that would be appropriation. So you may still end up having a vote whether to advance something beyond your report to the appropriations committee. I don't know if that's helpful.
Yes, Mr. Chairman, that is accurate. Hopefully, the committee would come up with proposed legislation. And then who you want to have on the task force voting to send that forward, again, is perhaps a choice left up to your discretion, however you think it makes most sense to do that. Obviously, a task force can't itself be the sponsor of legislation, but it can make a recommendation to, in this case, the Appropriations Committee.
Right, and then my follow-up question to that is, the design of it is almost the reverse of what a traditional task force would look like, where the House and Senate members of the task force are the voting members, the private industry folks are the non-voting members, but you're asking to set it up in the reverse. Help me understand that.
Mr. Chairman, and I do not intend to do that.
Okay.
Okay. So I'd want to delete I certainly don't want the members of the legislature to be non-voting members. And if you wanted to jigger with the numbers here so that you had more members of the House and more members on the Senate,
two legislators.
rather than just 2 legislators, if you wanted to bump it up to 3, that could make some sense.
Yeah,
So
got you.
that would make a lot of sense to me to actually have 3 on each side and then have those people be the voting members of the committee.
I agree.
So I apologize for the drafting oversight there.
Okay, go ahead.
Page 4 does give some direction to this task force to essentially, when you cut through all the legalese here, essentially it's saying, look at having a system where whether you're working as a fry cook or whether you're working at a construction company, wherever you're working, you're going to be automatically enrolled into a 401k as soon as you start, unless you decide to opt out. The employee is always free to say, I don't want to be a part of this. To look at that kind of structure, and also to make it so that there's not a penalty for transferring employers, so it's easily transferable. There's some language here about how we don't want this to create any additional obligations on employers under the Employment Retirement Income Security Act of 1974, the federal ERISA law that governs pensions plans. Obviously, too, the goal here, the task force, is not to be altering or amending or changing any existing 401k plans that any employer has. So if you're an employer and you've already got a 401k plan for your employees, the only difference potentially that the task force would be recommending was that the enrollment would be that you would have to opt out instead of the current system having to opt in. So that's the big idea here. Again, not a new idea. I don't want to make it sound like that I'm the only one who's thought of this. You get to some details, say on page 7, the task force would be recommending line 5, minimum, maximum default contribution levels, and then a process for employers to withhold employee contributions, et cetera. That's the big picture. And then on page 9 is the appropriation. There's appropriated $50,000 from the general fund. Again, why that number instead of some other number? I think this task force theoretically would be doing a little bit more than just having meetings. It should be looking at, does this make sense? Is it feasible? Can we really do it? And the real question, I think, is would the administrative costs of setting this whole thing up outweigh the benefits? That's one of the big questions, I think, that the task force would be looking at. So with that kind of high-level overview of this, I'd stand for any questions.
Mr. Chairman,
Mr. Vice Chairman.
I'm sorry, Representative Stith. When did you say that last study was done?
I believe, Mr. Chairman, my guess is that Representative Harshman would probably know more about that than I would. My understanding is that I believe it was done in 2016 or so, 15, 16, that timeframe. So within the past decade, but not within the past 5 years.
Thank you.
Representative Harshman.
Thank you, Mr. Chairman. What was that percentage you said in your introductory remarks of folks that are going to have Social Security only, basically? If that-
Mr. Chairman, 52% of persons aged 65 to 74 have no retirement savings at all. That's a big number. So the idea would be get that number down. That's both better for the individuals and also better for the state's bottom line 20, 30 years from now. So this is kind of a long-term plan, not something that's going to change things immediately for people, but get people on the right track.
Representative Stith, the bill requires the Wyoming retirement system to provide staff to support the task force. Have you interacted with WRS, and do they have the staff to do that? What's the demand look like, or envisioned at least?
Mr. Chairman, I have talked to Director Swindell, not as much as I should have, but with their budget, they should be able to support this.
All right, no further questions, committee. Thank you, Speaker Pro Tem Stith. Have our Wyoming retirement system. There you are. Come on up, Director Swindell.
Mr. Chairman, members of the committee, my name is David Swindell. I'm the Executive Director of the Wyoming Retirement System. The bill does direct that the director lead this task force. That would be me. The joke in the office was when this bill came out, "Oh, it looks like you have a job." And I said, "Well, it's or his designee, and you're looking very designee at the moment." But we can do this. I don't think it's a, there are a couple of concerns, and it has to do with the budget. The study requires this task force to include a market analysis to determine the feasibility of implementing the plan. Well, we do have a little bit to offer there. I know who to call. When we wrote the fiscal note, I estimated, just like the bill sponsor, $50,000 should be enough. I think we costed out $30,000 to hire a consultant, $20,000 to do some travel and pay some other meeting expenses. But the folks that you really want to have do this is the same folks that did this for Oregon. Oregon Saves is the program that's furthest along in the United States. They currently have, they're still in the process of rolling it out in tranches. But eventually it becomes mandatory for all of their employers. They are intended to be fully rolled out by 2021. They're running about 2 years behind. They're not going to get to the final tranches of the smallest employers until later this year. They have garnered $170 million in assets. The challenge, of course, is with all of those programs is financing the initial administrative costs, because you start with no assets. And then these assets will gradually grow over time. And the Oregon legislature, made a loan to the Oregon Saves Corporation. And I think their loan up to this point is about $5.2 million. And whether eventually the program becomes self-sustaining, and then if it really grows, then it becomes self-sustaining enough to be self-sustaining and pay back the loan both. You understand. The concern I have is I called up the folks from the Center for Retirement Research at Boston College and said, all right, I got this bill. They want to do a market research report, kind of like this 106-page study you did for the state of Oregon, which I have read, and it's very well done. And it has exactly what the study would require. And they gave me a quote on Monday, $50,000. That would soak up our entire budget. And the problem is that WRS has an exclusive benefit rule. Now, we have some expertise. We can give you some time and labor, but I actually can't spend any money on this other than what's appropriated. I can't take member money, which but constitutionally is for the exclusive benefit of members, and spend it to design or study a retirement plan for somebody else. So I do think it's important that the administrative budget here be robust enough so we don't have those kind of issues. My guess, Mr. Chairman, I need another 20,000, another 25,000, something like that. It would make my attorney much more comfortable. Otherwise, I'm sure we could get something for you with this budget. I'm not saying we couldn't, but it might not be from the preferred contractor that's actually done this for some other states. And the other thing I would tell you is you can take what they estimated back in 2016 when they wrote their report to how the program is rolling out. Yeah, they're 2 years behind, but it's tracking exactly as the study projected. They did a pretty good job. So I think that would be my recommendation to the committee as the contractor we would hire that would provide the bulk of this. So I don't know what the appetite of the committee is, but there's that situation. The other thing that I want to mention is that just so you're aware that both the previous study, which by the way was issued December 1st, 2018, I reread it. It's worth reading and will be primary reading for all the members on the task force. It's more of a survey of the problem, and it does kind of it's a study of the problem and it's a survey of potential solutions. This is more examine, a more narrow solution to this. I don't think I think this is a good background for this. But both this study as well as the folks that I talked to at Boston College, they expressed some doubt about Wyoming's ability to really carry this off because of our size. There's economies of scale in this business, as you can appreciate, and Oregon is 6 or 7 times our size with employment, size of the economy, number of employees. The previous study recommended, and this is likely to come out in this study, that you would pool with another state. There's still some issues to how to do that because successful programs do have mandatory employer participation in this thing, and every employer would be impacted by it. Even if you offer a retirement savings plan, you have to register and say that you offer it. You got some administrative costs there. And if you enroll in the plan, then okay, but then you still have to commit to taking out the deductions and forward them to the savings program and basically contacting the administrator monthly to see what the desired contributions of your employees are and implement that in your payroll and so on. And so you do have to successful programs do have this, mandatory requirement. I'm not sure how we would pool with Oregon, for example, because there are some penalties that they've imposed on employers that don't comply. I don't know if we could have the state of Oregon impose penalties on Wyoming employers. We'd have to work all that out. So that's an aspect that sounds good, but it may not be practical. The other thing I want to remind the committee is that successful programs do have mandatory participation, mandatory, automatic enrollment. You can opt out if you're an employee. 32% of Oregon employees have opted out. But initially you're in, and it has auto escalation. It has all these features. And I wonder what the appetite of Wyoming is to do that. If you know already we wouldn't do that, well, then I'm not sure you want to go forward and have a study, but that's up to you all. Otherwise, it certainly is a bit real problem. We know from behavioral economics that if you don't have an employer-sponsored savings program, it's just very difficult. People just don't save for retirement. Anybody can have an IRA, but they don't. And this method pays attention to behavioral economics. That's why this state, for public employees, adopted automatic enrollment in our 457 plan for new employees. New state employees are automatically enrolled at 3% of wages. That was back when we did that. That was pioneering. It served as the model for other states to go in that direction. I think Oregon is probably a good model for the rest, and a lot of other states are studying it. I think it would provide a basis for the study. Mr. Chairman, that concludes my remarks, subject to questions from you or members of the committee.
Questions for Director Swindell? Yes, Representative Wiley.
Director, when the state started the 457 deferred, was there questions if that was going to be sustainable?
Director Swindell?
Mr. Chairman, Representative Wiley, I'm not sure about that. WRS took it over in 2001. And at that point, it was already up and running to some degree. I'm not sure people were exactly cognizant of the cost back then. We have successfully achieved economies of scale. Back then, the administrative fee was 65 basis points when we took it over. It's 19 basis points today. That's starting to be amongst the best in class. But for a long time, the program had higher fees than the veteran class system simply because of size. Again, there's economies of scale in this. So we have $1 billion under management today in that program, and our basis points are 19 basis points. I don't know the history prior to 2001 and what the concerns are. I think I'm unqualified to answer that.
One follow-up, Mr. Chairman. And then with the 52% of retirees that have no retirement, do you know what the cost to the state is for the medical, just possibly?
Mr. Chairman, Representative Wild, I don't know offhand, but I know that there's a chapter in this study on that. They can be substantial, mostly in the hospital realm, Medicaid expenses, Medicaid, as well as some other bad financial impacts on communities where you have a bunch of poor people that are just getting by or having to rely on families and so on. There's a lot of things that go into that when people can't support themselves in retirement.
Additional questions, committee? Thank you, Director Swindell. Oh,
Just a
Representative
quick-
Harshman.
While you're there, Director, thank you, Mr. Chairman. Now, we voted to have the legislature be able to opt into the state 457, right? When did that happen? And that is not an automatic opt-in.
Mr. Chairman, Representative Harshman, that was voluntary. I can't remember when that was. It was 3
Like
years
about
ago?
8 years ago.
Maybe 8 years ago? The years wrong. I've been with the system 9 years.
I'd say it's
The
closer
years
to
was,
the 8-year mark. Since I've been in the legislature, it's been an option. I've been here 6 years, so maybe it's
Yeah.
the 8-year.
I think that's probably right.
That's an opt-in.
Yeah.
Thank you.
All right. Thank you, Director Swindell. Additional public testimony on this bill? Welcome, Mr. Shumway.
Thank you. Unmute that. Members of the committee, my name is Sam Shumway. I'm the State Director for AARP Wyoming. Excuse me. I actually served on the 2018 task force that looked at this issue, and it's been a few years ago. Mr. Chairman, to Representative Wiley's question, in 2018, the dollar amount, to put some dollars around your question about how much the state spends, was around $130 million a year that they're spending, and that's primarily with nursing homes. They've projected, and the Department of Health projected that number to increase, and it depended on a number of factors, to around $300 million a year by 2030. That's as and as you know, this is the cause is our baby boomers are retiring, but the root cause of this is they're retiring without any retirement savings. In 2018, when we looked at this issue, the task force realized this was a very real concern. We didn't have some of these numbers. We didn't realize the depth or breadth or gravity of this problem. And then we issued the report. And again, as Director Swindell mentioned, I would commend it to you for reading it. It really defines the problem and defines some potential solutions. Whether I share Director Swindell's concern about scale, economies of scale. Wyoming, as you know, our population is small. With that said, there are 47 states have taken some action to address this problem, whether it's a task force, whether it's a feasibility study, whether it's an actual program like the Oregon model. There are, I think, 16 states now that are implementing or in the process of implementing this type of a program. But there are options whether that's a multi-state, we get Montana and Idaho and Wyoming, and we band together as three Western states to, stand up a program and make this available to employees and employers in the state of Wyoming. That's a potential option. And there are folks who are researching and studying those types of options to see whether those are the most feasible. Again, we don't need, the problem is real. The problem is growing. The question is whether we want to give folks the opportunity to take some personal responsibility for that problem and start saving for themselves. These are 2018 numbers, but almost 100,000 jobs in Wyoming, their employer offers no kind of option for them to save. Now, they can go out and open up an IRA with a financial planner in their community, but that, frankly, it just doesn't happen. And so we are in support of this bill. We understand the potential impact, and with that, I'll stand for questions.
Questions for Mr. Shumway? Representative Harrelson?
Thank you, Mr. Chairman. Mr. Shumway. So currently numbers, this is a rough number, but currently it's about $102,000 a year to put an individual in a nursing home in the state of Wyoming. That's our average. It's actually higher some places and higher than that other places. So that's kind of the bottom line. I guess one of my questions is, there's not a financial advisor in the world that would look at someone that is in that boomer category who doesn't have a retirement that could even scratch that. I mean, that's depleted within moments. And so, and I'm not saying too little too late, but in some ways I believe we are a little too late for the boomer generation. Now, my generation could see a benefit out of this. I could see that as a reality.
Sure.
But it's a situation where the best time to plant a tree or start your retirement was 20 years ago or today. Concept doesn't work for the boomers. And so can you speak to that aspect of, if we have this huge bell curve that we're seeing, is this going to even scratch the surface of that?
Mr. Shumway?
Mr. Chairman, that's a fair point. And one of the things that we've seen as folks have studied this, you don't have to have $1 million saved for retirement. Even if you have a nominal amount, $50,000 or $100,000 saved, what that will allow you to do is remain in your home through using those dollars to leverage home services, and defer entering into a nursing home, which is, as you noted, are extremely expensive. Average nursing home stays are relatively short, but to the extent someone can have some money saved that will allow them to remain in their home, not have all of their assets depleted, and then they're just looking to the state to say, hey, put me in a nursing home, then that's what projections have shown, that even having something saved will defer a nursing home stay. But Representative Harrelson, to your point, yes, the best time to start saving is 20 years ago or today. So let's start today. And because this is a problem that isn't going to go away. Maybe we can't solve it for all of the boomers, but it's going to remain a problem.
All right, thank you, Mr. Shumway.
Thank you.
Additional public testimony on this bill? Do we have any testimony online? No? All right, I will close public testimony on House Bill 129. Committee, what is your pleasure? It's been moved by Representative Harshman, seconded by Representative Chadwick. Amendment on page 2.
Line 19, Mr. Chairman, I propose to change the 1 to 3. And then on line 20,
Senate.
actually, just on line 20, remove non-voting and insert voting. And then, so it would read, 3 members of the Senate appointed by the President of the Senate to be voting. Remove advisory members of the task force. That makes sense? You gotta add an S here and scratch out a non. Oh, I'm sorry. I gotta turn on the microphone. My apologies, Mr. Chairman.
Go ahead.
Mr. Chairman, so the proposal starts on line 19, page 2.
Okay.
And it would read, 3 members of the Senate appointed by the President of the Senate to be voting members of the task force.
Okay.
And then, Mr. Chairman, it would be the same amendment on page 3. 3 members of the House of Representatives appointed by the Speaker of the House of Representatives to be voting members of the task force.
All right, do we have a second?
Second.
Seconded by Representative Chadwick. I would have given the Senate 2 and the House 3.
Well, Constitution, we could do that. Twice the size.
Yeah,
not
that's
more
how
than
all of
3.
our committees are structured.
Yeah,
Did you want
I think I'll just,
to make that adjustment from that?
I think we,
Save that
there's
for
another
the
amendment
appropriation for
on the
separate.
appropriation, but I think we'll save it to the end. This is pretty simple here.
Okay,
So,
any discussion on the amendment? All those in favor signify by saying aye.
Aye.
Any opposed, same sign. All right, that amendment has been adopted.
This only other amendment, Mr. Chairman, was suggested by the director on line 7, page 9, changing that 50,000 to 75,000.
Okay, is there a second?
Second.
Seconded by Representative Chadwick. Discussion on the amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed, no? No. All right, that amendment has been adopted. Any other amendments? Discussion on the bill. Hey, Barb, will you call up to the Appropriations Secretary and let them know that we need Representative Zwanitzer? Dave? Go ahead, discussion on the bill, Representative Haraldson.
Thank you, Mr. Chairman. So I think, I'm not at all saying we don't have a major issue, but I do believe that we still have to ask a very fundamental question. Is this the job of the government? To establish a retirement fund for non-government employees and to manage that. Is it an issue? Yes. Is it our place where we can help educate and try open the door for people to get the understanding? Yes. Is it our place to establish it, manage it, maintain it? No, it really isn't. And I think that if we're not careful, we can, if we apply this concept across the board on every aspect, we could, it's a never-ending cycle of task force and trying to figure out how to fix a problem. The fact is that people, we do not have a culture of saving in this country, and now it's biting us, the state, because of that. So is it our job to fix the front side of it too? So I'm against this, not that I'm not for this. I'm for people saving. I want people to save. I want people to go out and get some retirement figured out. But I think that at the end of the day, we really have to ask the question, is it our job as the government to supply and provide opportunities for private businesses and entities and individuals to have a retirement? At this point, this is socialized retirement now. And I think that's really a question we have to ask ourselves is, are we okay with this concept of government ran and operated retirements for, I mean, in essence, it's like instigating our own, another social security system. I mean, it's really kind of convoluted, I feel. So it's dangerous to even walk down this road, I feel.
Vice Chairman Knapp.
Mr. Chairman, I would agree with Representative Haraldson. I think that when you start having to use the words mandatory for businesses, opting out versus opting in, this would be a huge administrative cost. And I know there's a couple, we dealt with one in the past, but probably going to be dealing with one here soon too for insolvency on retirement plans. So with that, I agree that this is something that's important to our citizens, but it's also a personal decision. And I would leave it at that.
Additional discussion, committee?
Mr. Chairman.
Representative Wiley?
Yeah, I just want to touch on this a little bit. I don't remember when I graduated high school or even when I graduated from the University of Wyoming, having them put me in a room and sit down with a financial planner and say, hey, this is what you need to do for the rest of your life to be ready to retire at a certain age. And I think this bill, well, the study is one thing, but if we move on beyond the study, I think this is going to affect a lot of our blue collar working folks that don't necessarily have the information that would benefit them to be able to prepare, from day one when they start their careers. And I just believe that this can both save the state a bunch of money that we're already spending, and at the same time help educate and put people in a good place so they can retire comfortably and don't have to worry when they get up there in years.
Representative Archman?
Mr. Chairman, not to, probably my comments are standing between us and a vote, so I don't want to belabor, but I think it's important to realize this is a study. And I think I'm wanting another committee, so I'm really going to shorten this up. But I think the idea, this is a study, and I think that is part of what we do as representatives of the people. I mean, we should help drive the culture, a culture of saving. And I get it. Maybe it comes back and there's some other idea, and establishing our own kind of system is going to be tough, but maybe there's other ideas. So I think that's what we're in the business to do, is kind of try to solve problems. And I think every problem has a solution. Just got to work at it, and we'll keep working at it. And again, a lot of the work we do here, it takes years and decades to bear fruit. And so with our eyes kind of on the future and the horizon, I think it's good. And then as much as anything, Mr. Chairman, it educates members of the body, and we just keep, and it's continual. These discussions never end. So that's why I signed on the bill. I think it's an important problem. We have a serious growing problem with a shrinking solution. And we think school funding's an issue. We think these other things, we're getting pretty old in this state, and it's happening fast. And so with that, Mr. Chairman, I encourage the members to support this, and we start kind of getting our minds wrapped around at least educating ourselves as a body. So thank you, Mr. Chairman.
All right. Representative Ottman?
Thank you, Mr. Chairman. I would just add to that, it surely is a problem, and I'm getting real close to dealing with this problem, but I had to take steps to make sure that I have a place to live when I'm not working anymore, and I have funds to pay for my food, and that was a responsibility that I was brought up learning. One of the things I thought about and did not do was to run a bill about financial training in high school. And so I think that would be a good place and could be beneficial next year if it went into effect. So training people up through community programs. We have Boys and Girls Clubs. They're very responsible. We have grandparents. We have people here in the communities. There's all of the Lights On programs. If we as legislators and adults and responsible people are concerned about this, then we need to be doing some volunteering, because I don't see how just funding everything through government budget is always the answer. I think one-on-one is more effective and quicker, but that's a personal opinion. Thank you.
Okay, Barb, will you please do a roll call vote on House Bill 129, Wyoming Private Employees Retirement Savings Plans?
Representative Chadwick? Representative Haroldson?
No.
Representative Harshman, did he leave an absentee?
Representative Harshman left an absentee vote for aye.
Thank you. Vice Chairman Knapp?
No.
Representative Newsom, I'll mark as excused. Representative Ottman? No. Representative Wiley? Aye. Representative Yin?
Aye.
Chairman Olson?
Aye.
5 aye, 3 no, 1 excused.
All right. Next bill for our consideration is House Bill 164, legal notice publication on websites. We have the bill sponsor, Representative Dave Zwanitzer. Glad we could give you a break from appropriations.
Thank you, committee. Oops, hope you can hear me. Thank you, committee. This bill here, I have to tell you, I'm a little excited about it because when I served in the legislature before, when this type of bill came, it was aimed at doing away with the newspapers. So this particular bill is brought to you by the newspapers, and they're here to testify, and I don't think anything I could say could convince you of that more than what they are going to say. But just to clarify, in our statutes, we have several statutes where you legally have to post a legal notice in the newspaper. If it's a foreclosure, or I don't want to go into all the different ones, but you're legally required to do that. Bills like this that have come before have said, hey, just put them on the internet and don't worry about the print media. So this bill in a nutshell, is brought to you by the organization that runs the newspapers in the state, and they're trying to be proactive, and they're saying, hey, listen, we like the idea, so we want to be able to not only print it in our newspapers, but this law would also make it that you print it in some sort of electronic media, and they have the statistics. And with that, I would stand for any questions, and Mr. Chairman, at your pleasure, I would invite the organization up.
Questions for Representative Zwanitzer? All right. Let's hear from the organization that represents newspapers.
Jim, go ahead.
Welcome.
Thank you, Mr. Chairman. My name is Jim Wood. I'm a recently retired newspaper publisher and the chairman of the Legislative Committee of the Wyoming Press Association. This bill is pretty simple. It's a couple of pages. What we did in the Press Association is we looked around at what some of the other states are doing and what we're doing in this state already. A lot of this is being done by newspapers across the state presently, and we just want to codify it into statute if we can. What it requires is for all newspapers to, in addition to publishing legal notices in their newspapers, as we do now, we would require them to also publish those same legal notices on their websites, their newspaper websites. Most of the papers in the state are already doing that. This would codify it into law. The second piece of this is that the Wyoming Press Association, about 10 years ago, we established a statewide website for legal notices. All legal notices published in newspapers in the state are published on this website, wyomingpublicnotices.com. We have updated it a couple of times, and it is a very user-friendly website where you can go and search by topic, keywords, geography, towns, whatever, any legal notice that is published in newspapers in the state. So we're asking you to codify that into law, to take it and say, okay, we're going to continue with publication of legal notices in the newspapers. They can be verified and also put them, we're for as much transparency as we can get. And so we feel placing them on the websites, we're pretty much doing that already. We want to continue that and make it available for anybody in the state to find them easily. We provide notice in the newspaper websites, and we also post them on the statewide website for anybody who wants to go looking for them. I would stand for questions.
I assume in some capacity, in some way, you basically polled your members to ensure that this is what they want. And I'm assuming your members are all of the newspapers or the majority of newspapers in Wyoming?
Yes, Mr. Chairman, yes. And we did poll them. And we have a couple of newspapers, small town newspapers that do not have websites or maybe only have a landing page. And the Wyoming Press Association Board of Directors has set aside some funding to provide to any newspaper in the state that needs a little bit of help finding somebody to host their website and to pay for that a little bit, at least for the first year.
Okay. But at least how it's written, it's on a website maintained by the newspaper. So if they don't currently have one, they don't have to, if they didn't have a website and they didn't develop one, they don't have to publish it on a website because they don't have one, correct? Other than your statewide website.
Yeah, we'll have them on the statewide, Mr. Chairman. We will have them on our statewide website, but we're also, through the association, we want to require all newspapers in the state to do that, to
Oh,
put
that's
it
a
on,
separate thing through your.
to put it on
association.
their own website.
This bill doesn't do that, but you want to require your members to have a website.
Yes.
Gotcha. Representative Chadwick.
Thank you, Mr. Chairman. Mr. Wood, so does this give an advantage or disadvantage to the smaller newspapers? Disadvantage perhaps to them, maybe an advantage to the larger newspapers, or vice versa. I don't know. Could you talk about that just a little bit for us?
Mr. Chairman, Representative Chadwick, I don't see how it would give an advantage. Each county and city government entity contracts with local governments. The local governments contract with the newspapers to publish those legal notices. In some instances in the state, there are competing newspapers, and they compete for the right to publish those public notices each year. And so, there would be, I don't see where there would be any kind of advantage of one over the other for requesting that all newspapers in the state publish on their websites. And most of them are already doing that. Like I said, there's only a couple in the state that don't have websites. And then the statewide website is a repository, yopublicnotices.com, wyOpublicnotices.com. Everything's up there as well. So I guess I'm not seeing where there could be any advantage.
Additional questions, committee? All right, thank you for your testimony.
Thank you.
Do we have any other public testimony in the room? I know we have one person signed up online. Yeah, go ahead. Go ahead and let the online person in. We do have one question for you.
Yeah, Mr.
Representative
Woods.
Ottman.
Just so I understand this, because I go to Mr. Chairman, I go to some of the county commission meetings and stuff, and a lot of that times they're saying about how extremely expensive it is to run those ads and how they would like to take them out of their budget. So what I'm wondering is how do you as an association, how are you funded, and would this be an additional burden on those entities? Thank you.
Mr. Chairman.
Go ahead.
Representative Ottman, the Wyoming Press Association is funded through a dues structure. Member newspapers pay dues, and we also have a statewide advertising service. Our executive director places ads for different entities, such as Blue Cross Blue Shield, people like that, in newspapers across the state, and the association gets a commission on the placement of those ads. So that's how our association is funded. As far as the cost to government entities, we did last year, called around and did some research comparing the amount of money in city budgets, what they spend on legal notices annually. And we found out that it's less than 0.5% of their budget that they're paying to keep the public in the loop on what they are up to by placing the public notices in newspapers. And what we're talking about by requiring them to be also placed on newspaper websites, and we have our statewide website as well. That's no additional charge to cities, counties, any government entity. It's, whatever they pay for publishing in the paper includes what we're adding in with the electronic art.
Yeah, in fact, this bill specifically says on lines 8 and 9 on page 2, at no additional cost to the person publishing the legal notice. So there can't be an upcharge for the digital post.
That's correct, Mr. Chairman.
No online testimony? No online testimony, no additional testimony in the room. Any additional questions, committee? All right, I will close public comment. Committee, what is your pleasure?
Move the bill.
Been moved by Representative Wiley and seconded by Representative Chadwick. Are there any amendments on page 1 of this bill? Amendments on page 2? Question on the bill. Barb, will you please do a roll call vote on House Bill 164, legal notice publication on websites?
Representative Chadwick?
Aye.
Representative Haroldson?
Aye.
Representative Harshman, aye by absentee. Vice Chairman Knapp?
Aye.
Representative Newsom, excused. Representative Ottman?
Aye.
Representative Wiley?
Aye.
Representative Yin?
Aye.
Chairman Olson?
Aye.
8 and 1 excused.
Okay, we have one final bill for our consideration. We have to be back in 10 minutes. This is House Bill 173, records available to post. I've messaged Representative Provenza. She can at least introduce the bill to us in 5 minutes. If not, we'll just stand at ease for a minute. And we may end up just picking this bill up. We'll see how quickly she gets here. Stand at ease. All right, committee, we will take up House Bill 173, records available to post at our Friday meeting. We will be adjourned.